Alô? Ok. Hello, good afternoon to all. Good morning to you, George. It's a great pleasure to have you here with us today. Oh, sorry. Now we are going to present the roundtable, Remember the Future, Law, Power, and the Empire of Impunity, em português. Lembrando o futuro, direito, poder e o império da impunidade. So I'm Professor Rafael Iorio. Our speaker is Professor George Bisharat, and we have here as a discussant Professor Paula Pimenta. So George, thank you to have you with us today, and thank you for your academic support to our event. And the stage is yours. So thank you so much.
Thank you very much. It's a wonderful pleasure to be with you again. I wish I were there in person, but even this virtual format is a pleasure and an honor. This, of course, is the first time I've spoken to you live since the death of our beloved colleague, Roberto Cantilima, and therefore I dedicate this talk to him. We live in a time when law itself seems to be disintegrating before our eyes. The breakdown of legality is visible everywhere in the genocide in Gaza that international institutions have failed to halt, in the corrosion of democratic accountability within the United States, and in the rise of ethno-nationalist regimes that treat law not as a restraint, but as an instrument of domination. The International Court of Justice, despite finding a plausible case of genocide in Gaza as early as January of 2024, has been powerless to stop the killing. The United Nations Security Council, paralyzed by 7 US vetoes, cannot enforce its own resolutions. Even the International Criminal Court, long delayed and intimidated, hesitates to act. The very bodies designed to protect humanity from atrocity now stand as witnesses to their own impotence. Yet we should never imagine that these institutions once functioned perfectly. The post-1945 legal order was deeply flawed from its creation, a structure that concentrated authority in the 5 permanent members of the Security Council, each with veto power, ensuring that legality would always yield to great power interest. As Lindsay O'Rourke documented in her 2018 book, Covert Regime Change, between 1947 and 1989, the United States alone conducted 64 covert regime change operations, from Iran to Chile to the Congo and more. Even at the height of the so-called liberal international order, the rules were applied selectively, and sovereignty was honored only when convenient to the powerful. We must also recognize that the post-1945 legal architecture, from Nuremberg and the UN Charter to the Genocide Convention and the Universal Declaration of Human Rights, already bore the seeds of its own unraveling. Excuse me. It was in large part victor's justice, a system conceived by and for the victorious Western powers, meant primarily to prevent renewed war among them, rather than to restrain colonial domination. Genocides against indigenous peoples, the Iorio and Nama in Namibia, or Armenians, had never produced a genocide convention nor occupied Western imagination as the Nazi Holocaust did. An estimated 10 to 20 million deaths in King Leopold's Belgian Congo never registered in the West, and frankly, they still don't. Only when Europeans turned their violence inward did the West codify limits to it. And that moral asymmetry haunted the system from the beginning. Decolonization, of course, pushed back as liberation movements swept Asia, Africa, and the Middle East. The General Assembly's new majority asserted a counter law of emancipation, the 1960 Declaration on the Granting of Independence to Colonial Countries and Peoples, the 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid, and even the 1975 resolution declaring that Zionism is a form of racism and racial discrimination. Together, these measures sought to universalize law beyond empire, affirming self-determination as both a right and, when necessary, a struggle. Yet the West dismissed these initiatives as soft law, in other words, not law at all, preserving its monopoly over what counted as true legality. Yet the spirit of those decades endures today in the efforts of South Africa, Brazil, the emerging Hague Group, nations that now claim the moral and legal leadership once monopolized by the West. But what we face today is not simply a crisis of enforcement. It is also a crisis of belief in the very idea that law should bound the powerful at all. The unmaking of law is not an accident. It is a project, deliberate, coordinated, and transnational. Its modern form began to take shape in the triumphalism of the post-Cold War era after 1991 and the fall of the Soviet Union, when the United States, proclaiming itself the world's indispensable nation, recast power as virtue and victory as legality. From that moment on, the so-called rules-based order became less a shield for the weak than a language for the strong. We make the rules, you follow our orders. The collapse of law we witness today is the long aftermath of that conceit. During the Cold War, the existence of a rival socialist bloc imposed limits on US arrogance. Washington had to present itself as a democracy that delivered justice better than its adversaries. That rivalry, paradoxically, produced a brief era of legal liberalism in my country, in the United States. The expansion of civil rights and the rights of criminal defendants in the 1950s and 60s. When the Soviet Union collapsed, that external check disappeared. The fear of ideological competition faded, and with it, the incentive to reform. What we see now, the United States Supreme Court's rollback of rights, its creation of presidential immunity, which I tell you was an earthquake in terms of jurisprudence in the United States, its contempt for international law, is the domestic face of a nation that believes itself unaccountable abroad. In the 6 sections of this talk that follow this one, I want to trace how that collapse unfolded, first in how the United States projected power, then across the international system it once claimed to lead. I will announce each section as I go through the talk so that you have signposts along the way to my destination. I'll end by asking whether we can still rescue law's emancipatory promise, whether amid the ruins we can remember the future that legality once imagined. The next section after the first one is the United States from law's guardian to law's gravedigger. For generations, people in the United States were taught that their country, my country, stood as law's greatest defender, the architect of a just international order. Yet, in truth, the US has been among law's principal saboteurs. The decline of legality has been bipartisan, and by bipartisan, I mean in American political parlance, that means supported by both major political parties, the Democratic Party regarded as the left, although I would argue it probably doesn't really deserve that term, and the Republican Party on the right. So the decline of legality has been bipartisan, supported by both major political parties, and structural, carried forward by every administration since the end of the Cold War. So I'm going to take you through this devolution through the various presidential administrations since the end of the Cold War, beginning with President Clinton, often thought of as a progressive or at least left of center president. Recall that President Clinton maintained the deadly sanctions on Iraq that caused massive civilian suffering. What I have elsewhere in writing argued amounted to genocide. He also pioneered so-called humanitarian intervention in the Balkans, claiming moral necessity while acting without UN authorization, a doctrine which later became referred to as R2P, or responsibility to protect. Both set precedents for violating law in the name of virtue. I'm going to digress just for a moment to talk about sanctions, because a digression because they're not strictly speaking law, but not so much a digression because I think they're an important part of this picture of which we should be aware. Sanctions became an instrument of US coercion, and they really deserve a discussion of their own. But suffice it to say for now that sanctions exploded in the post-Cold War period, such that the US now sanctions some 30 countries and 17,000 individuals worldwide. This does not include secondary sanctions, measures that we impose on countries, companies, and individuals that do business with one of our primary sanctions targets, let's say Iran or Russia. Because these secondary sanctions purport to regulate conduct by foreign actors outside of US territory, they violate the international legal principle of territoriality, which limits a state's jurisdiction to its own territory. Next, we come to George Bush, the second George Bush, elected in 2000. As you well know, President Bush invaded Iraq illegally, normalized torture, and institutionalized endless war. Those wars destabilized the Middle East and produced refugee flows that would later reshape European politics, and we'll come back to that in a little bit. President Obama, again thought of, generally speaking, as a liberal at a minimum, chose to, what in his words, look forward, not backward, refusing to prosecute Bush-era crimes and expanding drone assassinations. One strike notoriously obliterating a wedding convoy in Yemen. His 2011 Libya campaign, waged under that responsibility to protect doctrine, toppled Gaddafi and triggered new migrations across the Mediterranean. Obama's Syria policy, publicly demanding Assad's ouster while covertly arming rebels, helped escalate that conflict and displace millions. President Biden, another Democrat, another liberal in terms of American politics, promising restoration of law, became instead the chief enabler of the Gaza genocide, vetoing ceasefires, supplying arms, and repeating on more than one occasion fabricated atrocity tales. By January 2025, I'm sure many of you know, 50,000 Palestinians were dead, the number since rising above 68,000, with tens of thousands more wounded or missing. Gaza now has the highest proportion of child amputees on Earth. This horror may not prove an aberration, but a template for the future, a model for how powerful states may manage unwanted, displaced, or marginalized populations in an era of climate catastrophe and mass migration. Now, of course, we have President Trump for a second time. He, of course, accelerated the descent into overt lawlessness on an international scale, and crucially, also brought it home, that is, to our domestic scene. For decades, illegality abroad coexisted with the facade of legality at home. Trump erased that boundary. The culture of impunity that the US once exported now governs domestically as well. His unauthorized bombings of Venezuelan vessels in the Caribbean and Pacific over the last weeks, killing more than 70 individuals to date and with more promised, and his advisors' identification of targets in Colombia and Mexico reveal a government operating entirely outside legal constraint. At home, of course, he attacks judges, prosecutors, and the rule of law itself. And beyond this political dissent lies a deeper transformation in the economic order that sustains it. Now, I do not pretend to be a political economist, but I do know enough to know that we cannot ignore the reality that beneath this political and legal unraveling lies a deeper transformation in global capitalism. As historian Sven Beckert has argued, we are witnessing the demise of the neoliberal world order, the unraveling of the late 20th century system that promised integration through markets but delivered inequality and oligarchy. By the way, I promised to give you signposts, and I forgot to do that in this section. This section is the political economy of impunity. So the collapse of the neoliberal world order has not restored democratic control over the economy. It has instead empowered new concentrations of private wealth that operate beyond any state's legal reach. The rise of cryptocurrency, championed by radical libertarians hostile to regulation and committed to rule by technocratic elites, has spawned transnational fortunes, now pouring money into US politics, often aligned with pro-Israel and anti-regulatory agendas. This same dynamic plays out in the arms industry, where corporate giants not only manufacture and sell weapons, but also advise governments and underwrite the risks through export credit guarantees, political risk coverage, and war zone insurance of the very conflicts that generate their profits. This revolving door between government and defense contracting transforms war into an economic ecosystem. And this same logic extends to private military corporations. From Blackwater's successors, perhaps you recall the corporation Blackwater that provided mercenaries basically to the US government in Iraq in particular, but also to other governments in other battlefields around the world. It's now, it's dissolved, but its successors and Israeli firms marketing battle-tested crowd control systems. These actors operate in legal gray zones, privatizing war while evading the laws of armed conflict. Profit, once one step removed from violence, is now embedded within it. The Gaza Humanitarian Foundation, very recently, is yet another example of this trend. In this sense, the market, no less than the military, has become a theater of impunity. And the fusion of financial and political impunity reinforces a culture of lawlessness. As capital escapes accountability, so too do the states and leaders it sustains. This fourth section is the war on international law. The domestic culture of impunity extends outward in a campaign to cripple global accountability. The leaders of this campaign are the United States and Israel. Now, these two nations are not alone. Plenty of other states have either supported them or have flaunted the law on their own. But together, according to the Multilateralism Index developed by a team of researchers, the US and Israel rank number 1 and number 2, respectively, in the frequency of violations of the UN Charter since its adoption in 1945. Washington has long maintained hostility toward the International Criminal Court, even authorizing sanctions and the use of force against its officials, the so-called Hague Invasion Act passed by our Congress. Israel has threatened and intimidated ICC prosecutors, including Fatou Bensouda and Karim Khan, the last two ICC prosecutors, to block investigations of its war crimes. The US and Israel together now sanction and defame UN officials, such as Francesca Albanese, for reporting truthfully on Israel's genocide in Gaza. This is a war not on a single tribunal, but on the very principle that law might bind empire. It is waged not only on institutions, but also against the individuals and organizations that defend legality itself. Jurists, investigators, and advocates who are increasingly treated as enemies of the state. The hypocrisy of this campaign has rarely been clearer than in the case of the International Criminal Court and Ukraine. When Russia invaded Ukraine in 2022, the United States and its European allies rallied around the International Criminal Court. Washington encouraged the court's investigation, and Western European governments seconded lawyers from their foreign ministries to assist the prosecution. A donors' conference was convened in London to raise funds, and the eventual arrest warrant for Vladimir Putin was celebrated across Western capitals as a triumph of law over tyranny. Yet less than 2 years later, when the same court turns its attention to Israel's action in Gaza, the tone changed entirely. US officials denounced the ICC, threatened sanctions, and actually enacted sanctions, and Congress moved to punish any cooperation with it. The contrast was stunning. Law as a weapon against adversaries, and outrage when aimed at allies. The episode stripped away any remaining illusion that the so-called rules-based order was about law at all. It revealed what much of the global South had long understood, that for the West, legality is conditional on power, and justice is always selective. The collapse of legality is not only institutional, it is procedural. Across systems, from Washington to Tel Aviv to Berlin, we see a similar repertoire of techniques for undermining law from within. First, there are the assaults on the legal institutions themselves, the coordinated campaigns to delegitimize and intimidate courts, judges, and prosecutors who would hold the powerful to account. In the United States, Donald Trump has branded judges corrupt. He has called special counsel Jack Smith, that is the special counsel who was appointed to investigate Trump's crimes several years ago. He has called him deranged and even urged the Justice Department to indict him. In Israel, Prime Minister Netanyahu has attacked the International Court of Justice as anti-Semitic, and more chillingly, authorities in Israel have recently arrested the military lawyer who leaked footage showing a Palestinian prisoner being raped by Israeli guards at Sdei Timan prison. Such actions are meant to invert the moral hierarchy of law, turning prosecutors and judges into the accused and transforming accountability into treason. Second, there is the manipulation of evidence and deception of courts. Recent reporting indicates that Germany coordinated with Israel to omit or downplay evidence before the International Court of Justice of continued arms shipments, while publicly suggesting that they had ceased. And Trump's lawyers used similar tactics in defending illegal deportations of detainees by air, misrepresenting facts to the court to justify actions that plainly violated court-ordered constraints. Third, law is hollowed out through preposterous and intellectually incoherent legal theories designed to rationalize the irrational. In each case, the law becomes an exception rather than the rule. The situation is cast as sui generis, a unique crisis supposedly beyond existing norms. For example, Israel designated the Gaza Strip a hostile entity in 2007, a category unknown to international law, by which it sought to justify treating Gaza as a foreign enemy, as a rival state, rather than an occupied population, thus evading the responsibilities of an occupying power. In the United States, The 2025 strikes on vessels alleged to be run by narco-terrorists were justified as part of a non-international armed conflict, even though the targets did not qualify as enemy states or troops. The claim was that the War Powers Resolution and international limits on the use of force did not apply to did not apply because U.S. troops were not endangered. So it is both war and not war at the same time, according to which body of law the Trump administration wants to evade. This logic of exception blurs the boundary between law and power, turning legality into a flexible tool of domination rather than a restraint on it. Fourth, governments increasingly deploy a range of legal techniques to punish and suppress both fact-gathering and dissent. These include, but are not limited to, terrorist designations and sanctions as a tool of suppression. Groups and individuals who document human rights violations or criticize official policy, especially in Israel, but also in the United States, the UK, and Germany, are labeled as security threats rather than civic actors. Germany, for example, has not formally criminalized all criticism of Israel or Zionism, but recent measures have effectively narrowed the space for pro-Palestinian or anti-Israeli discourse, especially calls for boycotts of Israel or questioning Israel's legitimacy through institutional, funding, and administrative pressures, and in some cases, criminal prosecutions for extreme expressions. Such designations stigmatize dissent, block funding, and foreclose legal recourse. In 2021, Israel designated 6 of its most respected Palestinian human rights NGOs, including Al-Haq, which I once worked with, and Ad-Damir as terrorist organizations, criminalizing their advocacy before international tribunals. And in 2025, the United States followed suit, also sanctioning Al-Haq, Al-Mizan, and the Palestinian Center for Human Rights, 3 of the very groups cooperating with the ICC's investigations into Israeli war crimes. The UK, for its part, designated Palestine Action as a terrorist organization in July of this year. In these countries, legality is redefined. What exposes state violence is treated as terrorism, excuse me, and what conceals it is patriotism. Now, there is an entire discussion to be had as well about the alliance between the Trump administration and pro-Israel groups in civil society in this country that are bringing our most eminent institutions of higher education to heel and forcing them to adhere to Trumpist and pro-Israel ideological priorities. I won't go into that, but it's worth mentioning here. Together, these tactics, these 4 tactics, represent the everyday mechanics of law's undoing, the slow replacement of judicial reasoning with propaganda and of legal process with performance. They mark the point where the pretense of legality yields to the theater of power. To reclaim law will mean more than restoring institutions. It will require restoring truth itself, fidelity to evidence, to language, and to the discipline of reason. Without the renewal of honesty at law's foundations, even the best intentioned reforms will rebuild only the facade of justice, not its substance. Now I'm turning to section 5, the ethno-nationalist axis and the return of blood politics. The United States' long history of impunity has not existed in isolation. It has both protected and learned from Israel, whose defiance of international law has become a model for others. Israel taught Washington the politics of permanent emergency, the casting of all opposition as terrorism, the normalization of collective punishment, and the framing of occupation as defense. The United States, in turn, taught Israel the comfort of selective legality, the assurance that violations would never bring consequence. Each nation now mirrors and amplifies the other. Historically, the United States grounded its sense of exception in empire, the belief that its global dominance was divinely ordained and morally justified. Israel, by contrast, based its exception on ethnos, the claim that Jewish sovereignty sanctified the use of force and insulated it from legal constraint. But today, these two logics are converging. In the Trump era, US imperial exceptionalism has fused with white Christian nationalism, producing a distinctly American form of ethno-nationalism. The Muslim ban of Trump's first term, his equivocations after the white supremacist violence in Charlottesville, his present-day championing of white South African asylum seekers over genuine asylum seekers from Sudan, for example, are not anomalies. They are expressions of an ideology that defines belonging through blood, creed, and race. What once distinguished America's universalist imperial rhetoric from Israel's particularist ethno-nationalism is dissolving, and the United States is becoming more like the Israel it has long enabled. Now, of course, the imperial project was never free of race. Beneath the rhetoric of freedom and civilization that justified conquest lay a hierarchy of human worth, the same logic that today animates Israel's domination. But the current convergence simply makes explicit what was always implicit, that both projects rest on racialized entitlement and the conviction that some peoples are chosen to rule and others destined to submit. Israel has been a vanguard in the rise of ethno-nationalism in the late 20th and early 21st centuries. Long described as a democracy under siege, Israel has perfected impunity as governance. Its genocide in Gaza reveals the culmination of a legal doctrine that equates one people's security with another's extinction. In the summer of 2025, Israel bombed 6 countries in 72 hours: Syria, Lebanon, Iraq, Iran, Yemen, and Gaza, demonstrating the normalization of cross-border aggression. It, by the way, in addition to the occupations of the West Bank and the Gaza Strip, also now occupies parts of Lebanon and Syria. Only weeks later, the United States joined Israel in an unprovoked and illegal strike on Iranian targets, condemned as such by much of the world. Israel's model, security through domination, law through exclusion, has become a template for global ethno-nationalism. The United States has been an adopter and amplifier of this trend. We now import Israel's logic into domestic policy, militarized borders, the deployment of military forces within US cities, mass surveillance, and re-racialized immigration system. New policy preferences, as I mentioned, for white Europeans and South Africans echo a deeper cultural return to blood politics. And as I also mentioned, just this month, the US government closed asylum applications from war-torn Sudan, claiming that dangers there to civilians had abated. The blending of white grievance, evangelical nationalism, and Zionist theology dissolves any distinction between citizenship and chosenness. In both nations, legality is redefined, and what protects our people is lawful, what threatens them is criminal. From Modi's India to Orban's Hungary, from Europe's far right to Malay's Argentina, the same pattern unfolds. In Brazil, the Bolsonaro years offered a vivid parallel, the invocation of national purity, contempt for minorities, and the assault on environmental protections, all mirrored the same authoritarian ethos. Across Europe, anti-migrant legislation cloaked in the rhetoric of security repeats the Israeli logic of demographic defense. The wars we mentioned earlier in Iraq, Afghanistan, Libya, and Syria reverberated far beyond their borders, beyond the battlefields. The refugee crises they generated sent millions toward Europe, where liberal democracies that had once preached humanitarian intervention turned inward in fear. The backlash, the rise of the anti-migrant right from Hungary to France to the UK to Italy, was the domestic echo of lawlessness abroad. What began as wars for freedom overseas ended as assaults on freedom at home, completing the circle of impunity. The sixth and penultimate section is the mirage of strength. At first glance, the increasing resort to brazen displays of force by the United States and Israel might appear as proof of power. The US has bombed targets across the Caribbean, the Pacific, and Iran, while Israel, as I mentioned, struck 6 neighboring countries and continues to occupy territories in Syria and Lebanon. Each of these acts is presented as a demonstration of resolve of nations too strong to be constrained by law. In reality, however, such violence reveals not confidence, but decay. Empires in their ascendant phases rely on the persuasiveness of their ideals. In their decline, they rely on fear. Both the United States and Israel are suffering a profound erosion of moral authority, what Joseph Nye once called soft power, the capacity to lead by example rather than by coercion. That authority, painstakingly built over decades, is now being squandered through impunity as each new strike alienates potential allies and exposes the bankruptcy of the narratives that once justified their actions. Force may compel submission, but it cannot command respect. And when respect is lost, even the most powerful states become brittle, feared but unloved, capable of destruction but not persuasion. In that sense, these spectacles of dominance are also displays of weakness, the last reflexes of systems losing legitimacy at home and abroad. A telling example of this decline is unfolding even outside the arena of war. At the COP30, now underway in Belém, the United States has declined to send any senior delegation. The first time in decades, it has effectively vacated the global climate stage. Far from lamenting its absence, several participating governments and environmental leaders have welcomed it. They believe discussions may finally proceed without the obstructionism long associated with US negotiators, especially under the Trump administration. That the world's largest historical carbon emitter is now seen as an impediment rather than an indispensable participant captures the deeper truth. Moral authority, once lost, is not easily reclaimed. The architects of the rules-based order now find themselves unwelcome in the very forums they once dominated, a fitting symbol of a world that has begun to move beyond them. The final section, and I'm close to being done, is toward resistance and renewal, remembering the future. If law now lies in ruins, it is not because its ideals failed, but because power refused to honor them. Our task is not to eulogize law, but to reclaim it, to recover the possibility of legality as a language of liberation rather than domination. We must distinguish between the false universalism that served empire and the genuine universalism that insists on equality in dignity and protection. That recovery will not come from states that have betrayed law, but from transnational solidarities among scholars, like us, jurists, and citizens who still believe in its moral vocation. These solidarities are already emerging in universal jurisdiction cases pursued by European and Latin American courts, in coalitions of lawyers, artists, and activists demanding accountability for Gaza, and in networks of scholars building a global jurisprudence from below. Each effort, however modest, reasserts that law belongs to peoples, not empires. Today, the defense of law often arises where it was once dismissed as naive. That is Brazil's successful prosecution of former President Bolsonaro is one shining light, as is South Africa's invocation of genocide law against Israel in the International Court of Justice, and new alliances like the Hague Group, which includes a number of Latin American countries and also Malaysia, Namibia, Senegal, South Africa, that seek to restore international accountability. These are signs that the moral geography of law has shifted southward, that those once colonized by legality may yet redeem it. Now, to remember the future is to recall that other pasts were possible. Communities in Palestine, in Brazil, in countless places that once lived without hierarchy of blood or creed. It is to believe that these histories can still instruct us, that memory itself can be an act of resistance. For law, stripped of memory, becomes mere administration. But law joined to conscience and remembrance may yet become again a vessel for justice. Reform, of course, cannot just mean restoration. We cannot simply return to the status quo ante, to the flawed institutions that carried within them the seeds of their own failure. Constructing a new legal order will require imagination, the courage to draw from what was valuable in the past while envisioning what has never yet been tried. Every act of genuine reconstruction is an act of creation, part memory, part invention, part faith in the possibility that humanity can still govern itself by reason and compassion rather than domination and fear. If we are indeed living in a lawless world, our task is not despair but reconstruction, to rebuild legality from the ground up, animated not by the empire of impunity, but by the solidarity of accountability. Brazil and other nations in the global south now face the opportunity and the burden of imagining what a truly universal legality might look like, one grounded not in dominance, but in reciprocity. That is what it means in our time to remember the future. Thanks so much for listening.
So, thank you, George. Thanks so much for your presentation. It was a very interesting one. And I think we all learn a lot. So I'll pass to our discussant, Professor Paula, and to organize some ideas and some debate.
Pass the mic. Hello, Professor George. It's so nice to see you after we spoke so much through email. It's so nice to see that it worked out and we got to have you here today, virtually, but still. I took a few notes on your talk because I didn't read the text, right? So I took those notes while I was listening to you, and as you ended the talk, they seem a little silly to me, but I'm going to still tell you those just to provoke you to talk some more to us,
Sure.
if you can.
Sure.
But before, I would like to ask you to maybe, if you want, if you can, to comment on this talk, but about it not so much on its substance, but on its form. Both in the methodological way, if you could talk to us a little bit about how you come to build a research, and this research, like what are the protocols you adopt and the choices you make, the decisions you make, methodologically wise, but also in the sense that there are decisions involved in how you were going to organize that substance that you come to after you finish a research in order to present it, or to some people, and I kind of subscribe that research fully completes itself once you're writing it. And as we listen to you, we always feel very impacted with the way you organize ideas to present them. And that produces, in me, two main effects. First, that the way you organized was the only possible way, and that what you're telling me is true. So I would love to listen to you for a little bit, if you want, if you can, talk to us about that, about methodology and the relationship between substance and form in regards to producing academic texts, which are usually very boring, and also adopt protocols and models in favor of a sense of objectivity
Yeah.
and distance. And what they often produce is distance from the reader and the impression that what is being said is fake. And so if you can talk to us a little bit about that. And the other thing is in regards to the idea you advanced right from the title of your talk, Remembering the Future, because it seems to me to be very provocative. And as if you meant, hey, remember a promise, or remember the Enlightenment program through which we learned to believe in the future.
Yeah.
Which could be provocative because it includes the conclusion that the promise of the 18th century and also the promise that was carried by modern law never came to be, not fully because of the illegality abroad of imperialism, among other things. But also the notion of remembering the future reminds me of an author I really like. I don't know the name of the book in its original title in English, but to us it was translated to Capitalist Realism. The author is Mark Fisher. And he talks about many things, and he kind of dedicates himself to the relationship between capitalism and culture. But he also explores the element of devastation produced by capitalism is often accompanied by the belief that it's more plausible to us to think of the end of the world and produce, for example, movies about the end of the world or colonizing other planets, than it is plausible to us to believe in the end of capitalism, which is the cause of the end of the world. So I wonder if that's something that is in your horizon. And I mean that considering imperialism a capitalistic gesture and law and its relation with politics as epiphenomena of economic interests. And that law, conceived more in tune with enlightenment as restriction of attacks on freedom, is only defensible when necessary to protect capitalism, but not when capitalism has no more adversaries. You mentioned the end of Cold War, but I mean the fall of the USSR. So bourgeois legality would have limited reach. Now, as I listen to the end of your talk, I think that that's solved by your proposal of necessary imagination in order to deal with the problem that is posed in front of us. But I was then thinking about what would be available to us in the present would be to remember the future in the sense of remember not what law once was, which would be a classic reactionary gesture, right? To remember a past that didn't necessarily exist, but to remember to believe in what law could be. And I wonder if that's something that is in tune with what you're thinking. Thank you so much again for talking to us. I hope to see you again soon.
Thank you so much, Paula. First of all, let me thank you for inviting me to join to begin with. It's been a real pleasure working with you and making the arrangements to be with you today. I just want to point out you may have noticed that my background has changed from inside the house to outside in my backyard, and I apologize. I have a dog that is unwell and needs to go outside from time to time, and I fail to heed her call at my peril. So I'm standing outside for the moment, but I will soon be back inside. You've made a lot of very rich and very important suggestions and reactions to my talk. And I'll start off by by doing my very best to answer the ones that I recall. And if there's anything that I miss or overlook, please don't hesitate to follow up with by reiterating or reframing a question or whatever. Um, First of all, to start off with your questions about methodology and tone, um, I will you know on the one hand, when I do a presentation like the one I gave you just now, um, it's the culmination of decades and decades of research that range from from direct field work, as you know. I did field work in the Israeli occupied territories in the 80s, and I have returned there on a number of occasions, and the actual observed it, and the interactions that I've had with people are very deeply ingrained in my in my thought process and in my psyche and in my soul. Um, and while I absolutely respect and do my best to adhere to responsible uh, analysis and fact gathering, there is a difference between propaganda and committed scholarship. And what I seek is committed scholarship. I have never believed that the production of knowledge is an end in itself. It is always, for me, been a means to achieving a better reality for everyone. And so I do my very best to be faithful to canons of truth and objectivity to a point, but my goal, my objective is always to produce knowledge that can help forward a better future. Um, you know, the that includes, of course, knowing my topic, not speaking beyond my expertise, relying on reliable sources where I am, you know, if it's you know, academic research that I'm looking to, you know, finding authors and works that are themselves good examples of committed scholarship. Um, and in terms of, you know, how do I organize a talk like this? Well, of course, I begin first of all by thinking about my audience and, you know, who will be listening to me and what their perspectives are likely to be. I can't always predict perfectly, but I do my best. And come on, let's go. Uh, and I will say I actually gave this talk a few days ago in a slightly different form to an audience in Japan. And talk. Now, sorry, I'm my dog is done outside, and I'm able to go back in the house. Forgive me for that. Sorry, I lost my train of thought, but yeah, and organizing. I mean, I really want to map out a series of logical steps in a presentation that people can follow with me, and where the transitions from one, you know, one point, one stage to another make sense. And that's just, you know, the way my own mind works. And through many years of teaching in the classroom, you know, I think about the kinds of things that will resonate with my particular audience and that will also help them remain engaged. You know, people won't follow your logic if they're bored beyond tears. And so making references to things that I know will be recognized, that will make sense, that come from the experience of my audience, that helps. And I believe that the engagement of the, you know, the infusion of moral perspective into our work is also what makes an audience feel that what they're listening to matters ultimately. That makes them feel like this is a human enterprise that we're engaged in, and that it makes a difference in the real world. What we think, what we teach, what we discuss, what we argue in court, etc. Let me stop there, and you. I realize I only probably answered the first part of your set of questions, but if you want me to come back to something in particular, please let me know.
Yep, Beijing.
Say so.
Am I still there?
Oh, yeah.
Yeah. Hi. You asked me something? I kind of missed it.
I just said, I think I only answered maybe the first part of your,
Yes.
yeah. So I invited you if you want to restate or reframe any of the other parts that I didn't really address.
Oh, so in a nutshell, I asked you if your the proposal that is like the synthesis that you propose in the title, remembering the future,
Yeah.
if that is not only something you're proposing, but also something provocative in the sense that if that's the task in front of us, right, to remember that competence,
Right.
that belief of in the future that we learned from the Enlightenment program of the 18th, if that would also be a recognition that the bourgeois law, like modern law, is never came to be, and so the task in front of us would be to remember the possibility of it, what it could be,
Absolutely. Yeah.
and if you think or if you consider, if it's something you consider law as epiphenomenon of economic interests would have something to do with the fact that this law that never came to be was defensible when capitalism had adversaries, but not when it doesn't. You spoke about the
Yeah.
end of the Cold War or the
Right.
fall of the USSR, and in that sense, what we are facing, what our imagination can is going to face is the possibility of something that is not something anew, right?
Yeah.
Because that's what we're dealing with.
Well, certainly the title, Remembering the Future, and the ways in which I sort of explicated it in the talk are meant to be provocative, are meant to recall the better parts of our past, and in going back to the Enlightenment, highlighting the failure of our ideals to be met in actual practice. And this is, I think, an exercise worth engaging in because it is not always possible to construct something from, in fact, it is never really possible to construct something that is completely novel. There are, in terms of a social formation, there are inevitably parts that are reenactments of things that have been in the past, and in a way, I think recalling our past commitments is a way of reminding us of the goodness within ourselves, of the real of the real good and valuable commitments that we once made. Is law a an epiphenomenon of capitalism? And does this mean that regardless of our imaginations, it's going to remain so? Yes and no. I mean, I think these days, what part of what I was describing in this section on political economy is precisely the very naked sense in which capital is directing law or lawlessness in the current period. The unconstrained, unregulated creation of wealth these days, and I mentioned cryptocurrency as one example, I think it lays bare the relationship between financial and economic power and the realm of law and lawlessness. This does not, however, to my way of thinking, mean that that relationship between capital and law or lawlessness is inevitable, that we are incapable of resisting and creating a legal order that preserves and builds on what was good in our past and what needs to be done in our present and in our future. There are challenges in our world today, particularly climate change, that are unprecedented in human history, and that will require efforts, that will require cooperation, diplomacy, and law that we've never needed so urgently in the past. So to think that we will only face our challenges successfully by drawing on the past is not the case. And what we really have to do, I think, is as I said in the talk, is to fight together for this more humane future for ourselves. And I have not personally lost faith in the possibility that law can be a part of that struggle. I hope that answers better what you were getting at.
Yes, yes. I don't have any more questions. I just want to say that I remembered just listening to you answer my first question about form and all that, and what you asserted, how you choose what you're going to study and what you're going to talk about, and how you compose your conception of a responsible scholarship. And I remembered the first time I ever directed you a question, it was in an event like this a few years back.
Mm-hmm.
And I was just starting to study with Professor Kainch. And the question I asked you was about what you were telling us about what happened to Professor Bodin and the recall and all that.
Yeah.
And I was very impressed with the kind of text and the kind of talk, and it's not so common here. And it's something I liked a lot and that I incorporated in my own professional practice to include an element of moral when I choose what I'm going to do,
Yeah.
and also how I'm going to do it. And it reminded me that I asked you about cultural politics, if that's something you would motivate us to publish not only academic papers, but also in newspapers and what's going on. And you were very motivating. And so I am very glad to see that that was a correct intuition, and I hope our relationship lasts a very long time, Professor George.
Thank you so much, Paula. Me as well.
And me as well too. So thank you so much, George. Thank you for your attention and for your willingness to present this very interesting talk to us. So thank you so much. I would like to express our gratitude to you. It was a great pleasure for us all. So thank you for
Appreciate
the
it.
audience. And I hope to see you soon, George.
Inshallah.
Okay. Bye-bye.
All right.
Thank you.
Bye-bye. Thank you so much, everyone. Bye-bye.
É, porque a próxima mesa é 3h30, né?
Ah, 3h30?
Foi por isso que eu encerrei, nem abri para a audiência fazer pergunta, entendeu? Eu olhei para o relógio e falei, se a gente... Não, dá para dar um intervalinho, mas a minha ideia foi essa, ó. Vamos dar uns 10, 15 minutos de... Agora só tem latinos. Okay? Com anglo-saxão fica mais difícil, mas com latino dá para dar aquele...